Good morning. I think we're ready to start. I want to welcome you all here to the second Duke Hot Topics Conference in Patent and Copyright Law. Hope none of you had too much difficulty getting through our beefed up security on campus. We left names with folks, so we hope that wasn't too much a difficulty for you. We're very pleased to have this conference here at Duke. As you may know, and I know some of you are our students, so you certainly know that Duke Law School is acquiring quite a strong reputation, I think well-deserved in the intellectual property field, and that's possible because of a brilliant faculty and a growing faculty in this area, including not only our three tenured members of the faculty who are superstars in the IP area, but an extremely impressive group of people who have real jobs in the practicing world who lend their expertise to our students in courses, in additional courses, particularly in the patent and copyright area. Our reputation is also possible, of course, because our brilliant students who are interested in intellectual property issues, and certainly Michael Koenig and David Silverstein deserve special commendation for this conference, which is one very nice indication of the student energy and initiative that we have both at the law school generally, but in the IP area in particular. So I'm very pleased with their efforts and with the efforts of the IP Society more generally. And without further introduction, let me bring on Professor David Lange, who will introduce the first panel. Thank you.
Thank you, Kate, and let me just briefly add my own endorsement, particularly to that part of your remarks in which you credited the students who put this conference together with a truly outstanding job. These are first-rate students who've done, I think, an absolutely professional job of organizing this conference at great expense of effort and frankly, some expense of effort of money as well, but mostly effort, and they are much to be admired. As is our panel, whose members are among the most distinguished copyright specialists and judges in the country. We really are fortunate to have a panel of this distinction. Joe Beck, partner in copyright at Kilpatrick, Stockton in Atlanta. Judge Stanley Birch, a member of the 11th Circuit Judicial Bench, whose opinions in copyright have distinguished him as one of the leading commentators, leading judges and jurists on copyright in a number of cases, among them most notably recently the Win Done Gone case, in which Judge Birch's opinion, I think, is an absolute model. Ray Patterson, once the dean at Emory, now a distinguished member of the faculty at the University of Georgia, and continuing the dean of all of those of us who believe that interests in protection should be balanced against concerns for the public domain, while the rest of us were still cutting our eye teeth. Ray Patterson was writing vigorously, as he has continued to write during a very long and distinguished career, about the need to recognize the other side, once the dark side, now I think a side emerging into the light of copyright and protection. Alex French, who was a graduate of Duke in 1990, then a graduate of the Georgetown Law School, who is most recently minority counsel to the House Subcommittee that oversees intellectual property, once a part of the Judiciary Committee, and I don't know, Alex, whether it still is or not, but in any case, a subcommittee with, I think, an enlarged brief from what its brief was in the time when the 1976 Copyright Act was adopted. And finally, Dean Marks, senior counsel and, again, in charge of intellectual property at I was about to say AOL Time Warner, but I think I'll say Time Warner AOL in order to list the parts of the enterprise in the order of their value, and himself a distinguished member of the copyright bar. All of these individuals are qualified, eminently qualified, to speak to issues that justify the term hot topics. Our first speaker is Joe Beck, whose clients have included the estate of Martin Luther King, which he represented in protracted litigation with CBS over rights to Dr. King's I Have a Dream speech, and who most recently, or perhaps not most recently, but most memorably in recent times, was counsel for Houghton Mifflin in connection with that novel that Alice Randall wrote, The Wind Done Gone. It is a great pleasure to present or to introduce Joe Beck, a friend of mine, a friend of copyright, and someone it's well worth listening to. Joe?
Thank you, David. It's a pleasure and an honor to be speaking to this group at this law school and on this panel. I'm certainly not going to try to talk just about the SunTrust case. That's the reason for this little slip of paper. I'm going to talk about some hot topics. We have the author of that great opinion, SunTrust, sitting at my left, so I'll let him as he wishes, and you should ask him questions about it too. There are a couple of really red-hot topics in copyright law right now. One of them is the copyright term extension issue. I know that I heard questions while we were having coffee about that. And anticipating that, I wore this necktie. Anybody recognize this necktie? Can you see it behind the vest?
Starry Night.
Yeah, Starry Night, sure, by Van Gogh. Why did I wear the necktie? Because the painting, which I saw at the Art Institute in Chicago with the Gauguin exhibit, painting is, yes, in the public domain, even under the European law. But the necktie is still in copyright until at least the case comes to Judge Birch. We will see then. The other red-hot topic right now is downloading of music and videos. I know of no one better to talk about that than Dean and Alec, and so I wouldn't try to even touch those subjects with these two guys on the panel. I'm going to talk about some medium-hot and warm topics from my point of view as just a litigator. See if we can get the PowerPoint running. Yeah, let's... Four or five of these ideas. First, is there a new standard for injunction? And of course, I'll have to talk about the SunTrust case to talk about that. Secondly, rethinking originality. I have some, I think, original thoughts about that, hopefully. The discerning ordinary observer I'll conflate with originality because of the time. Transformative use, is it only a parody? And finally, and I've got to reach this topic, a moral rights First Amendment case out of Puerto Rico that you won't believe, and that, you know, I was privileged to be involved with representing. All right, let's deal with injunction first. Very quickly, and I know some of you are first-year students, let me go over this. To get an injunction in a copyright or most any other case, there are four things you have to do in the 11th Circuit, where Judge Birch presides. Show a substantial likelihood of prevailing, show that the plaintiff will suffer what's called irreparable harm. That means harm that can't be compensated in damages. Prove that the plaintiff's injury outweighs the injury to the defendant, and show that the public interest favors the injunction. 4 for 4 in the 11th Circuit. Some of the other circuits a little squishier. The traditional black letter rule, until Judge Birch's opinion and an opinion by the Supreme Court, has been if you show a likelihood of success, in other words, a good chance you're going to win, and all of this comes up in a preliminary hearing, then everything else tumbles like dominoes. If the plaintiff is likely to prevail, irreparable harm is presumed. That's the black letter law, has been. Secondly, irreparable harm almost always outweighs the harm to the infringer. Who cares about the pirate, after all? His harm doesn't count. And there's no public interest, of course, in allowing piracy to continue. That had been the law, has been. We looked at that because, as David indicated, I represented Houghton Mifflin in the Gone with the Wind, Wind Done Gone case. And we argued at trial, unsuccessfully because an injunction was entered, that the only time courts found, as opposed to assume this, were in situations that did not apply here. The defendant can't pay. There's a threat to the plaintiff's competitive position. And excuse me for speaking so fast. We only have 20 minutes, and I got a lot to cover. Threat to the plaintiff's position because of the cheaper goods flooding the market, fast-moving trends like video games, or inability to track. Let's say it's an offshore defendant. In those situations, irreparable harm is presumed. Maybe an injunction is appropriate. None of those apply in many copyright cases. And keep in mind, when we talk about copyright, we're talking about, in many cases, works protected by the First Amendment. We argued, and Judge Birch agreed on appeal, and I wouldn't be presumptuous to say what he said, except I have his words in front of us, that there was no copyright damage, much less irreparable damage, to the Gone with the Wind Trust, the people who own the copyright in the movie and book. As he said, SunTrust focuses on the market value of Gone with the Wind, fails to show supplanting of demand. That's the key issue. The fact that you criticize something and maybe taint it, harm it, leave its reputation injured, is not copyright damage as he found. And he also said this was crucial to a showing of fair use in a case like this, and we would argue crucial to the showing necessary for an injunction. In contrast, the evidence we offered specifically and correctly focused on market substitution and showed why Alice Randall's book would not supplant Gone with the Wind. How many of you have read Gone with the Wind? And seen the movie? Yeah, that's what I thought. Essentially, when I spoke in Russia, it was just the opposite. They'd all read the book and none of them had seen the movie, but they wanted to. And I'm sure it'll be made available.
New market.
How many have read When Done Gone? David Lange has read it. All right. I would urge you to do it now that Judge Birch has liberated the book. It's a great book. It's a satire, a parody, comment, and criticism of Gone with the Wind. It's, I think, going to be an American classic. It's only a couple hundred pages long, and I hope you'll see then why it's unlikely that our book would displace sales. During the hour we have later, if we have time, I want to tell you an anecdote about testimony Pat Conroy gave us in this case that I think Judge Birch found very interesting too. All right, so if there's no copyright damage, how can there be irreparable damage? We then went to what has now become the famous footnote 10 in the Campbell v. Acuff Rose case. Campbell v. Acuff Rose involved a song, Pretty Woman, owned by the Roy Orbison estate. A version of that was done, also called Pretty Woman, by Two Live Crew, a rap version, obviously. The question was, did that infringe? We'll get to that more in a minute. But in footnote 10, the court said that in most copyright cases, it's fairly simple. An injunctive remedy makes sense. Those cases are worlds apart from situations where there's a reasonable contention of fair use. Judge Birch found the same thing there, but I want to mention another case that he decided where I was not on the winning side. Greenberg v. National Geographic. In Greenberg, the plaintiff owned copyrighted photographs. National Geographic came out with a CD-ROM of 100 years of National Geographic. The National Geographic argument was that they had permission. The court ultimately disagreed with that and found it to be an infringement. I actually represented the New York Times and about 30 other publishers in an amicus brief, did not get to argue, just had to sit there and listen as Judge Birch beat up on my friend from Weil Gottschall. But in any event, this is what he said that I thought was very important. A lot of people have talked about the Greenberg case for other reasons and have not focused on this. He says, in assessing the appropriateness of injunctive relief, we urge the court to consider alternatives to an injunction. Now, think about it. This is, according to the court, a cold turkey infringement. National Geographic is available in other media. This is not going to be a prior restraint order under the First Amendment. It's not going to take something out of circulation, censorship. The book, the magazine is available. And even so, the judge very sensitively says, this is creative, so it infringes. Find another solution than an injunction. Ladies and gentlemen, I think that is one of the most, if not the most important case on this subject of injunctions in copyright cases. All right, moving on. Some second thoughts about originality. Those of you who are 1Ls, when you register a copyright, the Copyright Office gives you a certificate. That certificate says you've got a presumption of originality. If I'm the defendant, I've got to overcome that presumption in court. It's tough. The Copyright Office, as these guys know, doesn't really evaluate originality. It can't. I could register this necktie, and they would give it a pass. They can't evaluate originality. They don't have time, don't have the resources. Real question in my mind, should that continue? Those who want to broaden the public domain, like David Lange, who's one of the most influential writers in America on that subject, think about broadening the public domain by toughening up the standard of originality and applying what the Second Circuit has called the discerning rather than ordinary observer standard in a dispute. What that means is, if you're judging a copyright infringement, do you judge it the way a person would just look at something and say, well, they look similar. I'd probably buy the defendant's work if it were $2 cheaper. If that's the standard, there are going to be lots of infringements. Juries take plagiarism very seriously. They may have cheated on high school themselves, but they don't want anybody else to do it. And so it's tough being a defendant. And I represent, of course, both sides, not in the same case. Now, the discerning observer standard, promulgated by the Second Circuit Court of Appeals out of New York, says look at what is copyrightable. Look at that and look at what is in the public domain. Separate them out and focus on the copyrightable part. Again, Judge Birch has played a very important hand in this debate with his MyTech Holdings case. He uses the term virtual identicality, where you've got something that is fairly simple, like software. Not that it's simple, but from an artistic, creative, original point of view, it's often very derivative and not that groundbreaking. He wants you to look at something and make sure it's very, very close to prove infringement. I want to play, and if we have time afterwards, we'll play the case I've got in Houston right now. I represent Sony Music, Fox Pictures, a guy named Lil Bow Wow and Jermaine Dupri, and a song case. And the question is whether a song called Boys Night Out is infringed by our client's work, Bounce With Me. If we have time later, I'll play it. The reason I want to play it is this. Rap music, like a lot of music these days, is made sort of like a salami sandwich. You slice, you put in a drum track, you put in a bass track, you put in the vocals. When you listen to these two songs overall, back to back, I get, I'm troubled. And I can imagine a jury in Houston eventually being excited by this case. What I want them to hear, and what I hope we'll have a chance for you to hear, is the individual tracks of the song. Because that will enable you to compare the track of the song that really sounds similar and take out all the confusing parts that really don't. If we have time, we'll play that, and with the court permitting in Houston, that's the Fifth Circuit, so we won't get Judge Birch if we lose. Transformative use. Again, some 1Ls. Let me quickly say what that's about. Transformative use means taking a copyrighted work and creating something new from it. Think about it. Very exotic doctrine, founded by Judge Pierre Laval in an article in the Harvard Law Review that was picked up by the United States Supreme Court in Campbell v. Acuff Rose. I want you to listen now, technology permitting, to Roy Orbison's song and the Two Live Crew version. I say technology permitting. One of your esteemed graduates, Jennifer Jenkins, who flew the coop to London instead of being here today, was my able assistant in the When Done Gone case. We got ready to go to the second hearing. Everything was very rushed in a case like this. And it's 9 o'clock. I said, Jennifer, let's be sure the sound files work. They don't work. We get to the court, it's 10 o'clock. I said, Judge, as you know, we put in the CD of the Roy Orbison and Two Live Crew music, and I certainly wouldn't take the court's time now to have to listen to this. You and your clerk listen to it at your leisure. No, Mr. Beck, I'd like to hear it right now, he said. Well, having been a student of David Lange's, Jennifer Jenkins had been hard at work during that hour, and it worked, and it played, and let's see if it does now. First, Roy Orbison. It did earlier. Now this is the song that was in the Supreme Court case. Let's try it. Let's listen to what Luther Campbell did with that song. Is this transformative use? Go ahead. Words are different. You'll recognize the tune. Get the PowerPoint back up. How many of you think that's a copyright infringement? Judge? Didn't want to vote?
I Can't vote.
He can't vote. That's the one vote I wanted to get, too. But I think I can see something in his demeanor, perhaps. How many of you think that is transformative use? In other words, a fair use of the copyrighted work? Well, the Supreme Court thought it might be. They sent it back to the trial court saying this could be viewed as a African-American rap group's commentary on white bread country music. And I'm sure that that's what Luther Campbell testified to when he got back to trial. Case, of course, settled as they almost always do. So that's this transformative use doctrine. In our case, we argued that it was certainly if that's a parody, we argued that The Wind Done Gone was a parody. We had fabulous witnesses in this case. Birch, I think, complimented last night the quality of the testimony when he reviewed the case. John Sitter, who is the Candler Professor of Parody and Poetry at Emory University. By the way, those of you thinking about law school, would you rather be a lawyer billing 2,000 hours a year or a chaired professor of parody and poetry? I mean, really, isn't this one of the best jobs in America? John Sitter testified for us brilliantly. Barbara McCaskill, Professor of African American Studies at the University of Georgia. Henry Louis Gates, Jr., last time I checked, still at Harvard, chair of the African American Studies program there. Maybe he's now at Duke. He's a superstar. And Professor Gates gave us vital testimony in that case. And all of them agreed that parody copies in order to ridicule. Two key verbs. Copies, yes. You got to bring the targeted work up in order to make fun of it, but you've got to ridicule it too. Judge Birch said that Arthur Randall has fully employed those conscripted elements. You know, it's great language. Conscripted elements, copied elements, but I like conscripted better. From Gone with the Wind to make war against it. Clearly, in his mind, and certainly in our arguments, it was a parody. But what about satire? Is satire a parody? The Rogers versus Coons case is one of the leading cases that says a satire may not be a parody. In that case, there was a photograph of a couple holding a bunch of puppies. And it was, some people would say, a little quiche, a little bourgeois, and Mr. Coons thought it wasn't, so he made fun, but not of the photograph or of the puppies being held. He made fun of our materialistic society, and he was found to have been a copyright infringer. He copied, but did not ridicule. Dr. Seuss, another recent case in this area. Mimicry of a style without criticism is not fair use. What we had here was mimicry of the Dr. Seuss style. All of you remember The Cat in the Hat. But that was not the target of the criticism, of the parody, of the satire. The target was, or the subject was the O.J. Simpson trial. So again, mimicry without ridicule. A very interesting case that I have, my first big copyright case, DC Comics, for one of Dean's divisions, involved that very question, mimicry without ridicule. In that case, we represented DC Comics, which owns Superman and Wonder Woman. We sued a singing telegram service that had characters called Super Stud and Wonder Wench. And for example, if it's, let's say, a woman having a birthday party, the Super Stud character would come in wearing a business suit and he would say, "Hello, my name is Dark Dent, but I'm too mild-mannered with this crowd." And he rips out of his business suit, and he's got on a leotard that is a knockoff of our copyrighted and trademarked. Here, you can see it. There you see it. The lady on the left is not Linda Carter, but she does look like her. And the character on the right, disappointing to some of the audience.
I think it should have been a case for disparagement, dilution, Joe.
We did bring that one. We sued for disparagement as well. And the court said this is mimicry without ridicule, without bite. The problem was they were simply copying. They were not making a comment about either Superman or Wonder Woman. They're just getting a free ride creatively. So this doctrine that everybody feared after the SunTrust case was opening the floodgates to litigation is in fact fairly narrow. Remember, copy in order to ridicule. Mention one more case. David mentioned I have the privilege of representing the King family in this lawsuit against CBS. The CBS company had used Dr. King's I Have a Dream speech, a program with Mike Wallace, the 60 Minutes guy, called the the 20th Century with Mike Wallace, March on Washington. In this particular video, 62% of Dr. King's I Have a Dream speech was used verbatim. One of CBS's arguments, case eventually settled, we never got a ruling on this, would have been a fascinating question to bring to the court's attention. Was CBS's use transformative? Did they transform the speech? CBS's argument was that while Dr. King spoke, they cut to photographs to illustrate his words. When he talked about slaves, they showed a picture, an historic photo of a slave with his back bleeding from being brutalized. And various other photos were used. I would add, having taken the depositions in New York, they were all public domain photos. The reason was because CBS didn't want to pay copyright royalties. Martin Luther King registered his copyright in I Have a Dream. He registered 24 copyrights. That's how he made a living. He had the right to control, we said, the use of that speech for commercial purposes. This was a commercial purpose. CBS was selling the speech to the public, to public schools, I should say, for $1,000 a minute. Speech they didn't write a word of. Here was their transformative use argument. We can go to that. This illustrates it. When Martin Luther King is talking about George Wallace, and he says, the governor of Alabama with his lips dripping with the doctrine of interposition and nullification. This is a soundbite from the video. I hope it's going to work, because I cannot do it as well as Dr. King. Go to full screen. You back up to the, yeah.
Down in Alabama with its vicious racists, with its governor having his lips dripping with the words of interposition and nullification.
Now that is the CBS argument for and of course there are other clips like that. Throughout the speech, there are cuts to these kinds of scenes and Wallace and other historical figures. Is that transformative? We said no way, not even possible, forget about it. It doesn't transform the words of the speech. I think we would have won at the time, but I have to tell you there's a recent Ninth Circuit case involving Court TV's use of footage of Reginald Denny. He was the man unfortunate enough to be trapped and terribly beaten following the demonstrations after the trial of Rodney King. And in that case, Court TV used a brief clip to illustrate what was coming, and the Ninth Circuit said, well, that is, I think they said barely or thinly, Dean, do you remember? But just barely transformative use. In other words, illustrating something. So maybe this kind of integration of copyrighted work with other work would be a fair use. I don't want to take the time of the other panelists, so let me move on. I suppose we leave it with possibility that political parodies, which When Done Gone criticizes the racism in Gone with the Wind, may be entitled to greater fair use than silly parodies like the DC Comics case. A couple of other recent cases, Judge Posner, who, like Judge Birch, is a highly esteemed judge. He writes for the Seventh Circuit. Those who want to look at this, Tie Inc. is the name of the case. The site is there. Very interesting economic analysis of fair use. Kelly v. Aribasoft, in that case, the defendant had a website. He agglomerated photographs from all over the web, put them on his website in thumbnail size. The court said that is transformative, but when you can explode the photo into full size and download it, that is not. A Ninth Circuit opinion. Again, I think the best word on this is the SunTrust case for those who I think it's exactly what Judge Lavelle had in mind, what Judge Birch wrote about. All right, I got to talk quickly about moral rights. Here's the deal. Monroe case. Almost nobody knows about this case. I learned about it in a surprisingly almost painful way. In Monroe, the plaintiff was a songwriter from Puerto Rico. The defendant was a record label. They changed the words of the song. The plaintiff said, I'm hurt. I'm deeply hurt. Moreover, my father's memory is hurt. Court, this is a federal court in Puerto Rico. Goes to trial, $6.2 million in what are called moral rights damages for changing the words in a way that offended the writer. All right, that's chapter 1. Chapter 2, I represent BMG Music. They have a division called BMG Latin out of Miami. We got a guy who, big ego, he does the same thing. He changes the words to the song that we have licensed. Now, under copyright law, that's not a problem. We have a license. We have the right to do that. But once again, the writers say, oh, hurt, terribly hurt, offended. This is not what I had in mind. My moral rights, which is a European doctrine, not an American doctrine, my moral rights have been injured. This lawyer, he's pumped. He's just got $6.2 million and he should have retired. Instead, he's thinking, I'm going to really retire by suing BMG, which is part of Bertelsmann, an enormous media empire. We think, not a lot of sense waiting to get sued in Puerto Rico. We filed a declaratory judgment action in Miami. Here's the statute in Puerto Rico that's involved. Ray Patterson, I wish you could turn around and see this. This is extraordinary. I'm sorry it's hard to see. The key part, the Puerto Rican Intellectual Property Act provides that the author not only has the normal rights of copyright, right to benefit from, control the distribution of, dispose of, but he can also protect the integrity of the work. What does that mean? Well, the Puerto Rican Supreme Court 3 times has upheld that statute in the face of constitutional challenges. Now, we're in federal court, not state, and of course, Puerto Rico is not a state, but it's analogous. So you've got the analog of a state Supreme Court upholding constitutionality. Question, can they enforce this law against BMG? We filed our complaint and we argued, first of all, this statute regulates speech. Music is entitled to First Amendment protection. At the moment, David didn't mention, I have a case in the Sixth Circuit right now, which I represent, a band called Outcast, some of y'all know who that is, and they're labeled BMG, and the plaintiff is Rosa Parks, the civil rights icon. Ms. Parks, who's represented by Johnny Cochran, has argued that a song called Rosa Parks offends her right of publicity and violates 43A of the Lanham Act. We won the case at trial. It's on appeal in the Sixth Circuit. I hope the court sustains the view that that kind of work is entitled to First Amendment protection. At the moment it is. There's also dicta really in a Supreme Court case that says it is. Our argument is clearly music is speech. This statute I just showed you protects the integrity. What does that mean? Who can possibly know? Fails to give adequate notice of the conduct prohibited, is unconstitutionally vague and overbroad. That was one of our arguments. We also said it was preempted. 301 of the Copyright Act preempts state laws that protect rights equivalent to copyright in works that are copyrightable. David, this is mentioned here. 301F2B says nothing in this statute preempts, basically I'm paraphrasing, rights that are not equivalent to the rights conferred by 106A. Now that's, Alec French could write a better statute, but that's what that really means, I think, is this. We're preempting rights, moral rights, in works that are protected by 106A. Those are visual works. I'm talking about a music work in Puerto Rico, or actually in Miami. So the question is, does 301 preempt moral rights in music? I think the plaintiff could well have argued that Congress did not intend to occupy the field with respect to moral rights. A great case, another good copyright lawyer that all of us know, David Nimmer, who has a treatise, teaches at USC or UCLA, contacted me about this case to find out where it was going. He had a student that was going to write a law review note on it. The plaintiff agreed to settle for less than our first offer, and so we had to take that offer. It would have been a wonderful case to bring to Judge Birch, and we'll have to wait for another opportunity. I think I've actually stayed within my time. Thank you for your attention. I'll be around for questions. I have to go to New York right after lunch, but it's a pleasure to be here. Thanks.
Our next speaker is Judge Stanley Birch. As I've said, a member of the 11th Circuit Judiciary. Judge Birch was educated at the University of Virginia and then at Emory Law School, where he was a student of Ray Patterson, and since acceding to the bench, has written some of the most interesting and technically masterful opinions in copyright in recent times. There was a time when a copyright specialist would have said that the outstanding circuit in the country was the Second Circuit. I think any copyright specialist today would have to add the 11th Circuit as a place to go for opinions that are, in fact, truly luminous. What Judge Birch manages to do is to, in his opinions, is to combine a receptivity to arguments that might otherwise fall on deaf ears elsewhere with a technical mastery of the intricacies of the Copyright Act that is truly admirable. And you can see an example of that in the footnote in the When Done Gone case, in which he addresses the question of whether or not fair use should or should not be an affirmative defense. If you simply read that opinion and look at that footnote, you'll see something of what I mean. It's a great pleasure to introduce and welcome Judge Birch.
Thank you. If I may, can I just stay seated here? And is this mic alive? Okay, good. Can you all hear me okay back there? Back? Well, because so much of what these folks are going to be talking about are still sort of live issues, which perhaps it would be inappropriate for me to comment on directly. When they said hot topics, I had to try to come up with something original and something that, but yet might be of interest, and I predict will be a hot topic. We have a local news, legal news organ. I think they're syndicated around the country in different locations, called Fulton County Daily Report, which is kind of the inside about the legal profession. They talk about not only cases and things like that are going on, but about who's going where and all the good grit that folks like to read about every day, kind of the lawyer's gossip paper. One of it fascinated me a little bit to see an article or several articles and some exchanges in the lawyers' letters back to the paper earlier, I guess late last year, about the copyrightability of legal pleadings in that particular instance. As you know, most law is broken down at the practice level to either litigation or transactional work. There's some, and I used to do a little bit of both, having been have a tax degree, and I used to do some tax and transactional work, and of course, even in the intellectual property area, licensing. When I was doing the Cabbage Patch work, we did an awful lot of licensing. So I had the pleasure of doing both transactional work and litigation. I wrote an article that appeared in the National Law Journal, I guess, 10, 12, 15 years ago, very brief one, about attorney work product. And when I use the word work product, I'm not using it in the sense of protectability from disclosure and that sort of thing. I'm talking about just the work product that a law firm and an attorney turns out. I thought it would be interesting to revisit that. My perspective obviously has changed some. Obviously, I know a little bit more about it than I did as a young lawyer when I was doing that copyright work early on. And I kind of want to tell you how this developed. Actually, I was back in 1989 on a flight from Orlando to Atlanta. I had just been at a tax seminar down in Orlando looking at very interesting things like the valuation of incorporeal hereditaments and the vesting of the crummy trust and things that just really are exciting. And I was getting on the plane, and trust me, intellectual property law is a lot more fun than tax law is. And a lawyer sat next to me who I'd known for some time when I'd clerked on the federal district court in Atlanta. This young fellow was at the time, young fellow, we were all young then, was working for legal services, and we'd see him. He was a frequent flyer there, generally bringing civil rights cases and this sort of thing. He finally went into private practice at a time, and this will date us as well, when the concept of a condominium and all of the regimens and that sort of thing and was new, and those concepts, and he sort of pioneered that area. His law firm became not only a national but an internationally recognized firm, particularly in putting together large developments throughout the world, resort developments that would embrace golf courses and hotels and retirement communities and all that sort of thing. They specialized in all of the integrated different property regimes that had to be harmonized and integrated one with the other in order to have those things functionally work on a legal basis. Well, make a long story short, we were talking and catching up, and he said, I hear you do that copyright stuff. He says, we had a terrible situation that occurred lately. He said, I had an old-time developer friend come to me, and he said, I've been asked to participate in this integrated community as a developer of an aspect of it, and I've got all of the, usually it's a book size information on the property restrictions and regimes. Could you look it over and tell me if it's well done? Is this something I ought to become involved with? Because they have to, developers put a substantial investment into that sort of thing. They want to make sure that the ground rules are well stated. Well, the lawyer told me, he said, well, you know, I took these back and I started going over them, and they looked awfully familiar. In fact, we were able to discern very quickly that they were identical to the regimens that we and the property restrictions that we had put in place at great expense and cost to the people who hired us, and lots of time and effort on our part for a like kind of development in a different part of the country. And what really troubled him was this law firm, a very prominent law firm in Nashville, as it happens, had literally taken all of their work and simply substituted in the names, if you will, of this new development, and with some minor tweaking on it. He was quite upset about this and wondered if there was anything that could be done. And of course, back at those times, before I became a judicial officer, and I said, well, sure, you ought to sue the bastards for copyright infringement. And hoping, of course, that he would see the wisdom of hiring me to do that, I must say. But really, his question to me, he logically inquired, was, you mean that attorney work product to be protected by copyright? I said, well, I think so, but let me go study on this a little bit. And I went back, and of course, the first place you go to as a young copyright lawyer, and even an old copyright lawyer, is Professor Nimmer, the first Nimmer, not the son that Professor Lange talked about. I like to make that distinction. Professor Nimmer's book, I read, and let me read it to you. There appear to be no valid grounds why legal forms such as contracts, insurance policies, pleadings, and other legal documents should not be protected under the law of copyright. Section 113B of the 1976 Act suggests this conclusion by negative implication. ... By limiting the scope of copyright protection to, quote, useful articles, close quote, connotes that it is inapplicable to a book containing legal forms. Such a book does not portray a useful article, 17 U.S.C. Section 101. Because a legal form does not convey information, it falls outside the definition of a useful article. Moreover, as far back as the Second Circuit 1958 ruling in Continental Casualty versus Beardsley, despite some ambiguity in the opinion, this conforms with this conclusion. So I was somewhat elated and happy that at least Professor Nimmer thought there was no reason to prohibit the copyrightability, the first stage you have to look at, of legal work. I got to thinking, and this got me thinking about this whole topic, and one would think in the current, particularly current now, competitive lawyer mobile environment that characterizes the practice of law, that firms would pay a lot more attention to their intellectual property. I think we have the classic case of the cobbler's children wearing no shoes. There are many firms, large and small, that have established very prominent reputations in certain areas of practice. Frequently, the written work product of that firm represents and reflects years of experience, countless hours of drafting and revision. And therefore, by its very nature, the work product often must be published, thereby rendering it vulnerable to wholesale usurpation by some unethical competitors who have not invested the resources necessary to create that work. It seems to me that also instruction by a law firm of copyright protection program, by instituting a program, might also thwart the unauthorized reproduction, and I'll tell you about a case as a side in a minute, of client files, including legal memorandums and correspondence, that often precedes defections of lawyers from their firms. Unauthorized copying and the use of the contents of client files that are particularly properly noticed, because you don't have to do it, but it certainly makes it easier when you're arguing before most district judges, would facilitate any infringement action that the firm decided to pursue later. Although non-competition agreements are rare in the law firm environment, the firm nevertheless may be able to limit its exposure to a raid on its current clients, I would suggest, by controlling its written resources through an aggressive program of copyright protection and management. Intellectual property lawyers are always counseling with clients about the client's management and protection of their intellectual property. I would be amazed to find out today, and I've questioned some folks because I've been out of the practice now for some 13 years, how many law firms have an active intellectual property management operation in their own firms? Very few. At this juncture, it should be emphasized, I think, that we are not discussing the law itself. Obviously, that's not copyrightable for those of you who are new to the area. It's perfectly clear that no compiler can have a copyright on the law itself, notwithstanding some circuits that Professor Patterson has criticized. However, I think you have to focus on the generation by attorneys of documents on behalf of clients involved in transactions that are governed by the law and look at whether they may be copyrightable and to what extent. Let me talk to you about some interesting issues I think that this raises. One might say, well, given the pervasive use of form books and now databases in the profession, many practitioners may question the enforceability of a claimed copyright in a work that is a composite of innumerable contributions of lawyers throughout a work's evolution. To understand and appreciate the interface of copyright law with a typical generation of work product in a law office, an examination of certain copyright concepts, of course, for some of you first years, would be helpful. Many, if not most, legal documents may well fall into what is statutorily defined as derivative works, compilations, collective works. And Section 103, of course, clarifies all that for us if you need to read that. Thus, as a practical matter, it seems to me a firm desiring to assert a claim of copyright in its work product should establish a copyright evolution file relative to the work, documenting what, if any, predicates were utilized in the drafting and creation of the final product. One might not be surprised to find an experienced practitioner able to create from his or her own tangible, intangible experience and thoughts a legal document from the proverbial whole cloth. I suppose after you've drafted some sort of deed restriction or insurance, you read all the cases, the good lawyers read the cases, they manifest in the deed restriction or the insurance provision or the bond indenture or whatever they're drafting, all of that knowledge and experience so as to take care of certain problems and to ward off other problems. And they can do this really without looking at anything. Nevertheless, I think it would be prudent to contemporaneously document the sources utilized by the drafter when they are, whether they be cerebral or intangible. Thus, whether the product is an original work of authorship is a compilation or derivative variety, one crafted only by the wit, skill, and experience verbalized in expression, we should examine the next concern of the law firm, that is, who owns the work product? So you have a copyright management system in, you've documented how a particular document has been put together. If it's a document that's very important that you think you'll have a market for. Copyright authorship and ownership are distinct concepts because copyright rights are, as you know, separable and transferable. Accordingly, in the context of attorney work product generated in a traditional law firm by partners and associates, I'll use the traditional words, I'm not so keen on all the new concepts, at the behest of a client, the relationship of the parties, it would seem to me, then have to be analyzed, and this raises some interesting ownership issues, and I think also some ethical issues. Central to the issue of ownership is the legal fiction embedded in Section 201B, which is the work made for hire section, which says, in the case of a work made for hire, the employer or other person for whom the work was prepared, is considered the author for purposes of this title, and unless the parties have expressly agreed otherwise in a written instrument signed by them, owns all of the rights comprised in the copyright. Accordingly, while the actual composer of the law firm's work product may be an associate, toiling away in the catacombs for a little more pay than a federal circuit judge makes, the law firm, by operation of law, becomes the author entitled to copyright ownership. The firm owns it. The associate is a traditional, typical common law employee. Anything that associate generates under the employ of the firm becomes the firm's under this fiction of Section 201B. While this result may seem perfectly rational to the lawyer, it may well come as a surprise, however, to the client who is paying for the document preparation. But what few clients, even sophisticated corporations with in-house counsel, may understand is that any interest it may have in the document is merely possessory. It does not extend the copyright on the expression embodied in the document. Clients paying for it, but they really don't own it. They only have a possessory interest in it. Strict technical interpretation of copyright law. Query, although the ethical rules may not affirmatively require an attorney or a law firm to disclose to the client that the attorney or firm will, absent transfer to the client by writing, retain the copyright in the document. Would it not seem proper to do so, my ethical friend? In at least one other profession, architecture, in which the issue is more graphically presented, no pun intended, the professional typically affirmatively undertakes to put the client on notice of such a claim of copyright. As intellectual property becomes more and more valuable and concomitantly better understood, there are far more intellectual property lawyers out there, folks, than there ever used to be. We used to have a meeting in Atlanta of intellectual property lawyers and not more than a phone booth back in the early days. Now it's proliferate. As this becomes more valuable and better understood, perhaps savvy clients and attorneys will exercise more deliberate attention to copyright rights as an important element of the professional relationship. Moving then from the potentially thorny issue of the attorney-client relations, including conflicts of interest, the law firm desiring to secure its intellectual property must next confront an internal thicket of legal and business concerns. In ascertaining the ownership of attorney work product generated within the confines of the law firm, the relationship of a firm's constituent attorneys to the firm must, of course, be examined in the light of the work-for-hire statute and its judicial construction. In a traditional law firm, the environment of the firm has the right to control and supervise the manner in which legal work is performed. The degree of exercise of that supervision may vary depending upon the nature of the project, the skill and experience of the attorney, and the seniority of the attorney, which may or may not be commensurate with the experience depending upon the area of the law involved. Although subject to these variables, which may be important in a particular situation, the firm would typically and generally be the owner and statutory author of an associate's work product. The lines become more faded, though, I suggest to you, when you're considering, in the traditional sense, partners. With the various incarnations of law firms today, including partnerships, professional corporations, partnerships of professional corporations, and the newer limited liability corporations partnerships, absent some sort of written agreement between the, quote, firm and its constituent partners, it may be difficult to ascertain ownership in a work produced or work product produced and created by such a partner, unlike the somewhat easier associate situation. This discussion, I think, indicates the safe and practical course to be undertaken if a law firm desires to secure ownership rights in its attorney's work product, and that is to enter into written agreements whereby the attorney assigns to the firm, pursuant to sections 201D, 294A, and B1, all of his or her right, title, and interest in any copyrighted work of a legal nature produced during the term of his or her association with the firm. Reliance on such an express transfer under the Copyright Act is far sounder than the alternative constructive approach of the work-for-hire doctrine method. Finally, another application of the copyright law may also provide helpful to law firms and businesses where client information is of value. All of the documents and records, including correspondence prepared on behalf of clients or for internal firm use, are also subject, obviously, to copyright protection. at least to prohibit the wholesale replication by a defecting attorney, usually accomplished on the firm's own photocopying machine. Where the copying of such records is unauthorized or for an improper purpose, pirating a client, let's say, the firm would be on solid ground, I would suggest to you, in seeking the return of the copied documents, as well as a bar against any further copying of those documents. Where there is no non-compete agreement, this approach may impede, if not entirely thwart, the exodus of client information that would facilitate a raid on the firm's clients. Let me give you a case I had when I was back in practice. I had a client come to us who was a large manufacturer of printing presses, and somebody let me know if I'm running. Okay. Printing presses to the industry that print newspapers, offset printing presses, the web presses. They had a fellow who was they only had 2 salesmen, if you would call them that, and their job was to go throughout the country on a regular and systematic basis, gather information from all potential clients, and they're obviously very limited, the number of newspapers or periodicals that use these kinds of presses. And of course, these presses sold for millions of dollars when they were purchased and lasted for a number of years. So you only had to make 1 sale a year, and you would have a very good commission if you were the sales representative. But the sales representative was also on a salary. They could go to the finest hotels, and they were expected to take the clients out to the finest restaurants and wine and dine them. And not only the meet and greet sort of thing, they were also to accumulate information. How old were their presses? How was their business expanding? All of this sort of thing. And they were paid handsomely to do this, the representative. And the sales representative, or whatever you want to call him, what's the name? At any rate, this fellow had no non-compete agreement. He got, surreptitiously, a better offer from a competing company, that there weren't too many, that sold these presses. Would you come join us? We'll give you a signing bonus of rather large 6-figure sum. And of course, we want you to use your knowledge and expertise, which in many states you can't prohibit somebody from doing, in taking some of those clients away from your prior employer. Well, obviously the prior employer had invested thousands and thousands of dollars, and much time and effort, putting this person out there in front of all these people. And one of the most valuable assets they had were his files, where he had made all these notes. They knew about when the presses were starting to get old or going to need replacement, all of those kind of vital trade information. Well, this individual literally photocopied his file drawers, and he didn't have that many to photocopy because it's of a limited clientele. And these people came to me and they said, we don't have a non-compete agreement. You know, we've been told by 2 law firms we can't stop this fellow. I said, well, maybe we can. Maybe we can. I said, all of that information that he copied, I say, has a copyright that's owned by the company. He was a common law employee. I say we go into federal district court and we obtain an injunction for the return of all of that property, that is, all of those documents, and to prevent him from further copying them. The district judge agreed with us. We settled the case very quickly after that. Hadn't seen that used too often, but it is a creative way of using the copyright law, where there you had mass replication. I mean, just pure replication. We didn't have all of these nuanced issues that Joe was discussing earlier with you. To complete the story that I began with, my friend's firm contacted, and I really told him that this was probably the better way to do it. I drafted some pleadings, complaints, requests for injunctive relief. We sent those to we call the senior partner at that Nashville firm. We said, well, here's a copy of our pleadings. We've sent you the 2 sets of documents. You can look and see how identical they are. And of course, they all had to be filed, because these are regimes that have to be filed in county deed offices and that sort of thing. So there's no question about what was produced first and what was produced second and all that sort of thing. They were matters of public record. We sent that to the law firm and we said, we're going to sue you unless you disgorge any profits you made, give us an apology, and think of how devastating this will be when your client finds out. We don't know what you charged them, but we bet it wasn't the duplication fee from the photocopying machine. They settled very promptly and pledged that they would not do this again, and in fact that they would associate the firm in all their future endeavors in this area, because they obviously didn't have the expertise in-house to do it at the level that they should have been. So I thought I'd bring to the table this morning, since we have a bunch of lawyers and aspiring lawyers here, another perspective on copyright law and how it might be useful in the internal operations of law firms. I think, to be perfectly candid with you, that the amount of protection one would get for legal forms and particularly legal pleadings is going to be somewhat limited, obviously. But I do think it will prevent rote replication. I think there are some areas arcane enough or individualized enough where if you have a good program internally of documenting the creativity and what predicates, if any, that you used in producing work, that you may have something that will hold up in court if you need to use an injunctive tool. But again, I think there is that sensitive issue that one needs to do is when you're working for, let's say you're working for a bank or insurance company, they're paying you a great deal of money to draft a form that's going to be used over and over and over again to protect the bank. They probably, though, don't want that competitive bank just taking the work product that they're using and replicating it. But by the same token, you need to fess up to the bank. Now, you know, you're not going to own this copyright in the work unless there's a written transfer. And I suspect once in-house counsel becomes more sophisticated in intellectual property, and they may already be, Dean, you could tell us, demanding this kind of transfer when they have this kind of work product created. So I just thought that I'd throw that out there for you all today. It kind of kept me out of the trouble of trying to talk to some of these subjects I probably ought not be talking about because I may have them appearing before me, and hope it would be something that's of interest to you. Thank you, David.
Our third speaker is Ray Patterson from the University of Georgia, and formerly, as I've said, Dean at the Emory Law School. I have known Ray for the better part of 30 years, but I don't think I've ever actually asked him how it was he got into copyright, and I'm a little embarrassed to realize that, Ray, as I'm now introducing you. All I know is that when I came along, Ray was already there, and he had already written one of the genuine foundation documents in the law of copyright, an early treatise or book on copyright and historical perspective. And I think it's been one of the things that has enlivened Ray's writing over the years, and it's prolific writing, that he always brings to the things that he has to say about copyright an understanding of copyright and historical perspective, so that when you are talking to Ray or you hear Ray speak, you will understand that what is informing his judgments, and I'm sure that will be true this morning, is a very deep command of the antecedents of American copyright and its origins in the experience of the English people. Ray Patterson, delight to welcome you.
Thank you very much, David. Since the judge has set the precedent, and I always follow precedent, I think I will just speak from here, if I may. In answer to your question of how I got into copyright, it was courtesy of a student of mine. I had completed my coursework at Harvard Law School and was preparing to write a dissertation for my SJD, but I didn't know what to write about. And talking with a student one day, he said, "Why don't you write about copyright? Nobody knows anything about it." And so I decided to take him up on that. And it proved to be, I did not know how right he was, because when I submitted my dissertation to Harvard, it took 2 years to get it approved. And I was told later that there was no one on the Harvard faculty who felt competent to evaluate the dissertation. They then contacted a noted bibliographer in London and asked him to evaluate it. But he turned out to be a communist, and in those days, that would not do. The second reader they got was a noted American bibliographer, but he died. Finally, they asked the director of the rare book library at Harvard if he would evaluate it, which he did, and it passed. And 2 years later, I got my degree. I like to make use of students, and my remarks this morning are based on a work in progress which was suggested by a student who is now working with me on the article. He said, why don't you write an article about personal use of copyrighted material? And I looked into it, and it occurred to me that what Justice Holmes said is true. We need study of the obvious more than investigation into the obscure. And my argument that personal use is a constitutional right is based on 3 obvious but unrecognized ideas. One is that the limitations of the copyright clause are more important than the grants. The second is the difference between property and intellectual property is that the essence of property is the right to exclude. The essence of intellectual property is the right to use. And finally, the essence of the free press speech clause in the First Amendment is not the right to print or speak, but the right to read or hear. Now, let me go back to my point that the limitations in the copyright clause are more important than the grant. This is because the limitations are necessary for the 3 copyright policies contained in that clause. Those policies are: 1, that copyright promote learning, because the clause so states. 2, that copyright protect the public domain, because copyright is available only for original writings and only for a limited time. The first condition, of course, means that works in the public domain cannot be captured by copyright. The second means that all copyrighted works eventually go into the public domain. And the third policy is the one that is the most subtle, and that is that copyright provide for public access, because the exclusive right in the copyright clause that Congress can grant is only the exclusive right of publication. At least at the time that the framers drafted the clause. And I wish I had time to give you evidence of that point, but you can read the article when it's published. Now, my argument that these policies, my argument is that these policies are the constitutional base for personal use. My reason for saying that personal use is a constitutional right is that it exists by reason of a limitation that Congress is duty-bound to respect in the exercise of its copyright power. Now, the one question that bothered me is why has the personal right as a constitutional right not been acknowledged? And the reason, I think, is that it was an integral part of copyright from the beginning because of the narrow scope of copyright, and consequently, it has always been assumed and not articulated. The, the development of new forms of communication, the television and the computer, has meant that the custom of personal use has not been strong enough to protect the right of personal use, because the distinction between property and intellectual property has been ignored. As I said earlier, the essence of property is the right to exclude. The essence of intellectual property is the right to use. Now, there are three unpermitted uses of copyrighted works that we can identify. One is an infringing use. Another is a fair use. And a third is a personal use. We have difficulty, courts, present company accepted, have difficulty in distinguishing these various uses because they all involve essentially the same conduct. That is, copying. And the distinction really depends upon a definition of copyright. And I have not seen, either in the statutes or in the cases, a definition of copyright. But if you look at Section 106 and the other provisions of the 76 Act, it seems clear that copyright can be defined as a series of rights to which a given work is subject for a limited period of time. Now that, again, seems obvious, but the significance of defining copyright in that way is that it means there is a distinction between the use of the work and the use of the copyright. Or rather, a distinction between the work and the copyright, and therefore a distinction between the use of the work and the use of the copyright. And this definition provides the basis for defining the three uses. Infringing use is an unpermitted copying of the work for commercial purposes. It is a wrongful use of the copyright. Fair use is unpermitted copying of a work for the purpose of creating another work. It is a lawful use of the copyright. Personal use is a copying of the work by an individual for his or her non-commercial use. It is a use of the work. It's not a use of the copyright. Now, to me at least, all of this is so clear that I wondered why it hasn't been recognized before. Why has it not become a part of copyright jurisprudence? The short answer is that it's not to the benefit of copyright holders. And the long answer is that copyright holders are the ones who have shaped copyright jurisprudence. And their greatest success in shaping copyright was in the 1976 Act, in which they accomplished two goals. They made personal use a subset of fair use, and then they set about to destroy fair use. Now, they accomplished this goal in two steps. In Section 106, Congress made the right to copy, which historically had been a component of the right to publish, independent of the right to publish. In Section 107, the first codification of the fair use doctrine, Congress said that the fair use of a copyrighted work, including use by copying, for purposes such as comment, criticism, news reporting, teaching, parentheses, including use by multiple copies for classroom use, scholarship, and research, was not an infringement of copyright. Now notice these exemplars. I don't know that anyone has ever told me this, but I think the first three exemplars, comment, criticism, news reporting, are examples of fair use. The second three, for teaching, scholarship, and research, are examples of personal use. So, what Congress unwittingly, I think, did was to make personal use a part of fair use. They then made the fair use subject to four factors to which undermined the right of fair use. And the best example is the fourth factor. It's not merely the effect of the use on the market, but the effect of the use on the potential market. And any copyright holder who cannot come up and say, you are interfering with my potential market, should get into another business. Now, the publishers then set about using litigation to create what I call judicial copyright statutes to destroy the right of fair use, especially for teaching, for scholarship, and for research. All you have to do is look at the Kinko's case, the Texaco case, Geophysical Union against Texaco, and the Michigan Document Services case. Now, I'm convinced that all of this was part of a well-conceived plan from the beginning to shape the copyright in 106, fair use in 107, litigation after the statute was enacted, and the clue is that the publishers realized that if they did not have a licensing system, the courts would not go along with them because of transaction cost. So they set up the Copyright Clearance Center, which was set up in the 1970s just in time for the 1976 Copyright Act. And the publishers continually ignore the limitations on their rights in the statute. Notice, Section 107 says the fair use of a copyrighted work, including use by copying, is not an infringement of copyright. I read this copyright notice in a book just the other day. Quote, copyright 2002 by Carol Birkin. All rights reserved. No part of this publication may be reproduced or transmitted in any form or by any means, electronic or mechanical, including photocopy, recording, or any information storage and retrieval system without permission in writing from the publisher. And they give you the address that you can write to in order to get permission. Now, I want to return for a few minutes to the point that the right of personal use is a constitutional right. The Copyright Clause empowers Congress to create a property right. And I ask you, as a matter of common sense, does it make any sense that the framers would have empowered Congress to create a plenary property right for a few citizens at the expense of all of the citizens? Does it make any sense that the framers would grant a plenary property right that enabled a copyright holder to control the press for private works and then adopt an amendment that denied Congress any power to regulate the press? Now, most people see the Copyright Clause and the First Amendment as contradictory, but not consistent. I argue that they are consistent because, as I said earlier, the essence of the Free Press, Free Speech Clause is not the right to print and speak, but the right to read and hear. And the source for that conclusion is the Licensing Act of 1662 in England, which was a copyright statute as well as a censorship statute. And the Licensing Act is the reason for two provisions of the U.S. Constitution, that is the Copyright Clause and the First Amendment. The important characteristic of the Licensing Act is that it made the publication of unlicensed books a violation of the statute, but it contained no provision prohibiting the writing or reading of, in terms of the statute, seditious, schismatical, heretical, or treasonable books. In other words, the essence of censorship was the denial of access. And the Licensing Act makes the free speech component of the Copyright Clause apparent. The promotion of learning is a free speech component. The provision for public access is a free speech component. And the protection of the public domain is a free speech component. Now, I would like to return to an obvious point. That point is the importance of ideas. We continually overlook the importance of ideas, but it is ideas that determine our action. And copyright is essentially a set of ideas. There are two sets of ideas: property rights and political rights. Historically, the framers of the Constitution subordinated the property rights to the political right to learn. That scheme has been upset by the extension of copyright to new forms of communication. They have given the property idea the upper hand in copyright jurisprudence, and the best example I can give is the Supreme Court's latest and most disastrous copyright decision, Eldred against Ashcroft. This is why I say it is important that we recognize that the right of personal use is brought out from under the radar, so to speak, and to recognize it as a constitutional right. Thank you.
Thank you very much, Ray. Our fourth speaker, Alec French, occupies what must be one of the truly best jobs in all of copyright as minority counsel to the House subcommittee that oversees a whole bunch of things, but among them intellectual property. This subcommittee has an interesting history, and I want to just say a word or two about it in order to make Alec's position there all the clearer. For reasons I myself don't entirely understand, but which I believe to be true nonetheless as a descriptive matter, the House subcommittee that deals with intellectual property is, I think, unmistakably more influential in the construction of intellectual property than is the Senate committee or the Senate subcommittee that does the same kind of thing. Now, it would be impolitic for Alec to agree to that proposition, and I don't expect him to do so, but the very fact is that in the 17 volumes of legislative history that accompanied the enactment of the 1976 Act, it is almost inevitably the House subcommittee's legislative history that is treated by courts and by scholars as authoritative, and the Senate subcommittees that is really given relatively short shrift. I would lay some credit for that fact, and I believe it to be a fact, at the feet of the man who was, at the time the 76 Act was enacted, chairman of that subcommittee, Robert W. Kastenmeier of Wisconsin, who, had you worked for him, would have meant that you were not the minority counsel, but rather the majority counsel. This is not a road down which I want to go, Alec, and will not, but I believe it's fair to say that even with that shift in the control of the subcommittee, this subcommittee is at the very heart of the process by which legislation is brought forward, vetted, revised, drafted, redrafted, and finally approved. And though I do not mean to give the Senate short shrift, I still believe I'm correct in saying that the House subcommittee is where the principal action is. Now, Alec cannot endorse this view, I think, and hope to return to Washington unscathed, but I do want you to understand he occupies a position that anyone who is interested in copyright policy would be glad to occupy, and it's a great privilege to welcome him today. Thanks.
Thank you. Thank you, Professor Lange. I'll try to politically or politely explain my thinking on that, which is that the Senate Judiciary Committee actually doesn't have a subcommittee anymore to deal with IP because then Chairman Hatch, then who became ranking member, is now chairman again, decided that he loved these issues so much they could only be dealt with at the full committee level. And so he got rid of the Senate subcommittee that dealt with IP matters. And of course, full Judiciary Committee in the Senate side is, and has been for years, kind of wrapped up in things like nominations. So they get very little done other than what they don't get done, which is nominations. Under either Republicans or Democrats, I might add. And also, I need to point out, as minority counsel, I work for the ranking member of the subcommittee, who's a guy named Howard Berman, a Democrat, obviously, from Los Angeles. He's my boss. Anything I say here that sounds smart, you can attribute to him. Anything that's dumb is my own opinion. I notice also I'm the only person up here not wearing a tie, and unlike Joe, I was not trying to make a statement with my attire. I've only done a few of these things. I always seem to get the dress wrong. I was down in Miami, I was dressed in a suit and tie, and Professor Patterson was dressed in a natty sports shirt. I went up to Boston last week, I was dressed down, and everyone else there was in coat and tie, so I went halfway between this time with a jacket and no tie. Still got it wrong. There's got to be some kind of email list I'm not party to. Anyway, the program indicates my topic's going to be concerns about DMCA effects on fair use, much ado about nothing. That was the working title I emailed to Mike Koenig when he indicated the printers were going to beat him up if I didn't get something in quick. But my remarks, I think, are going to try to make somewhat broader, and if I understand this crowd, even a little more provocative. My title now is Current Copyright Law, the Source of Overwhelming Benefits and the Subject of Overblown Concerns. Two premises underlie my thinking. My first premise is that copyright and fair use are inextricably linked. Creators frequently make fair use of other copyrighted works. That's what we've heard today quite a bit from Joe and the professor, as well as of public domain works. If it weren't for fair use, many copyrighted works would never be created. Conversely, fair use is meaningless without copyright. If a copyrighted work is never created, there is no opportunity for fair use of it. Fair use proponents cannot assume creation of future works and spend all their time arguing about what uses can be made of existing works. True fair use proponents must ensure there is sufficient incentive to create future works. My second premise is that we're all living in what could be termed the golden age of copyright creation and fair use. Today, there are more copyrighted works available in a greater variety of formats and on more platforms than at any time in history. Consumers have more options than ever before in the choice, price, and use of those works. There are literally tens of thousands of copyrighted business, productivity, and entertainment software titles available for PCs, Macs, PDAs, PlayStations, Xboxes, GameCubes, Game Boys, and the Internet. All are widely available in stores, and many can be downloaded from legal services through the Internet. Even the usefulness and acceptance of open source software depends directly on the fact that copyright protection gives teeth to its licensing structure. Unparalleled numbers and types of copyrighted magazines, newspapers, photographs, needlework designs, and graphic designs are widely and legally available both online and off. Publishers have made concerted efforts and substantial investments in ebooks, though they have not yet found a sufficient audience. Music is also more widely available, and I mean through legal channels, than ever before. Digital subscription radio has arrived, thousands of channels of non-interactive webcasting are being offered by hundreds of webcasters, and digital over-the-air radio is around the corner. Music has become increasingly available for on-demand download and streaming. Major label music has been licensed for on-demand download or interactive streaming through PressPlay, MusicNet, Rhapsody, Full Audio, RioPort, eMusic, Streamwave, CenterSpan, Music Match, Real One, as you may hear, AOL, and the label's own websites. Movies are also more widely available than ever before. Movies are now sequentially released through theaters, pay-per-view, DVD and videocassette rental, cable, satellite, and broadcast television. Even though the broadband market is too small to sustain a business for the foreseeable future, movie studios recently rolled out MovieLink.com, a service that allows cheap online downloads of over 350 major films. This golden age for content represents a golden age for consumers and fair users. They have more to choose from on more formats with more flexibility and at better prices than ever before. How did this golden age for content creation and fair use come about? Well, causation's a hard thing to prove, but it is worth noting that this golden age has occurred under the current copyright regime, which includes the DMCA and the Net Act, and other frequently maligned copyright laws. Of course, there's always going to be a vigorous philosophic debate about the extent to which law can influence behavior. But it's the opponents of current copyright law who claim that these laws are somehow harming creation and fair use. I'm simply examining their premise, and I think it leads to the opposite conclusion of what they draw. If current copyright law is in any way responsible for the state of creation, consumers, and fair users today, it appears to have been a boon. There is, in fact, some evidence that current copyright law bear a causal relationship to the existence of this golden age I described. For example, the DMCA is partly responsible for the movie industry's adoption of the DVD format. As a result, the DMCA deserves credit for providing consumers with a wildly popular new choice for watching movies. Let me belabor the point. Consumers would not have the choice of viewing movies on DVDs, a choice they've exercised in historic numbers, if movie studios had not made their movies available on DVDs. And movie studios would not have made their movies available on DVD if it weren't for the CSS copy protection included on DVDs. Just ask anyone involved with that process. It wasn't going to happen without CSS. Finally, the DCSS hack of CSS would have made CSS utterly useless and thus caused movie companies to stop putting their works on DVDs if the specter of DMCA liability had not thwarted further development of the DCSS hack. I know some of you probably want to shout about now, but the consumer can't copy their DVDs, so how does that benefit them? Well, my first response goes back to my first premise. If there's no DVD movie in the first place, what good is a theoretical ability to copy it? The situation in other countries supports a correlative, if not causative, link between strong copyright protection, creation, and fair use. Countries with weak IP laws are not hotbeds of creativity. For example, China and the Russian Federation provide notoriously weak copyright protection to copyrights in movies and software, respectively. The piracy rates are over 90% in both those countries. Anything you buy on the street, 90% of it's going to be pirated. It's therefore no surprise that China and the Russian Federation have weak indigenous movie and software industries. Just ask someone who's trying to start up a business there in software or movies, and they'll tell you they can't do it because the piracy rate's too high. Of course, some argue that weakening copyright protection in the U.S. will lead to even greater creativity and its attendant benefits for use. But why would we risk reducing the unparalleled creativity in the U.S. today on the theoretical possibility that more creativity might result? At least from a congressional perspective, I believe the mantra should be, if it ain't broke, don't mess with it. To be fair, most of those who propose weakening current copyright laws do not suggest that we adopt the Chinese or Russian copyright regimes. Instead, they propose rolling back specific provisions of copyright law based on specific concerns. Many of these concerns surround the DMCA, and I won't go into the details of the DMCA because I think it's been widely discussed enough that most of you all probably have at least had classes on it if you're here. One concern Congress hears frequently about the DMCA is that it will eviscerate fair use. Well, it's been 5 years since the enactment of the DMCA, and we are, as I posited, in a golden age for fair use. So theory aside, the empirical evidence all around indicates that fair use is alive and well under the current copyright regime. The cases so far do not support the contention that the DMCA is eliminating fair use. In fact, the Second Circuit in the Universal versus Corley case and the Northern District of California in Elcomsoft explicitly rejected claims that the DMCA eliminates fair use. These courts found that the language of the DMCA specifically protects rather than restricts fair use. The DMCA does not prohibit circumvention of technologies that prevent copying, distribution, display, etc. In other words, it contains no prohibition on conduct that might be termed fair use. The DMCA only prohibits the sale and manufacture of circumvention technologies and the circumvention of access controls. While they found that the DMCA does not, on its face, restrict fair use, the Corley and Elcomsoft courts did acknowledge that the DMCA may make the technical means of exercising fair use harder to come by in some circumstances. However, the courts didn't seem overly concerned about this outcome. Rather, the courts concluded fair use would still be possible. They also found that nothing in the law guarantees consumers the most convenient exercise of fair use privileges. The court cited specific examples of how the DMCA accommodates fair use. While a film student can't copy a CSS-protected DVD, he can record the segment he wants off a video cassette or a broadcast. If a speculative future arrives where only DVDs are available, the film student can record off the screen display the fair use segment he wanted to use. Similarly, while a book reviewer cannot directly cut and paste paragraphs from a copy-protected ebook, he can manually type those paragraphs into his book review. Thus, the courts concluded that even under the DMCA, fair use is alive and well. If the DMCA prohibition on circumvention of access controls does end up having an effect on fair use, there is a safety valve. The Copyright Office is empowered to create exceptions. The Copyright Office, in fact, has just embarked on its triennial rulemaking to craft such exceptions, and folks who believe the DMCA has had an impact on fair use have the opportunity and are right now presenting their evidence to the Copyright Office to create statutory exemptions. Another concern some folks have expressed with the DMCA is that companies like Lexmark are using it to engage in anti-competitive behavior and in ways not contemplated by Congress during DMCA enactment. I don't share these concerns. The DMCA does not trump antitrust law, and the Lexmark case supports this conclusion. Just to give a brief description of the case, using the DMCA, Lexmark secured a preliminary injunction against Static Control Corporation's distribution of the SmartTech chip. However, nothing in the DMCA or the injunction prohibiting SEC from suing Lexmark nothing in the DMCA or the injunction prohibits SEC from suing Lexmark under the Sherman Act, the Clayton Act, or any other available theory for anti-competitive conduct. The facts of the situation, not the DMCA, may prevent SEC from proving anti-competitive conduct by Lexmark. While Lexmark has 10 to 20% of the printer market, HP has over 50%, and several other large companies like Xerox, Toshiba, and IBM are significant printer manufacturers. So Lexmark doesn't appear to have sufficient market power to force consumers to buy its printers and thus buy its toner cartridges. On the second point, rather than proving an unanticipated distortion of the DMCA, I think the Lexmark case illustrates how it's supposed to work. Lexmark uses encryption to prevent unauthorized toner cartridges from accessing copyrighted software programs that enable toner cartridges to operate in Lexmark printers. In reliance on this encryption, Lexmark offers consumers 3 options for toner cartridges. 1, a low-price cartridge that can be used only once and then returned to Lexmark. 2, a mid-price toner cartridge that has been refilled by Lexmark. Or 3, a high-priced toner cartridge that the customer can have refilled by any party. The encryption, with the DMCA behind it, allows Lexmark to offer consumers this range of options. The District Court for the Eastern District of Kentucky found that SEC violated the DMCA by selling its own toner cartridges containing a SmartTech chip. According to the District Court, the SmartTech chip circumvents encryption protecting access to Lexmark's copyrighted software programs, tricks Lexmark printers into thinking a proper toner cartridge has been inserted, and thus enables SEC refilled toner cartridges to operate in Lexmark printers. Well, if this situation was allowed to continue, if SEC could sell cartridges containing the SmartTech chip, Lexmark would no longer offer consumers a variety of toner options and price points. Wouldn't make economic sense. Instead, Lexmark would sell only the high-priced refillable toner cartridge. This outcome doesn't benefit consumers. Conversely, Lexmark's ability to use the DMCA to protect its business model does benefit consumers. It's worth noting also that in this case, SEC is not some innocent innovator simply trying to build a better mousetrap. As the court found, SEC not only violated the DMCA, but also infringed copyright. SEC did not fall into the reverse engineering exception of the DMCA because its SmartTech chips contained identical copies of Lexmark's computer programs, rather than independently created programs. If it had been innovative enough to create its own computer programs, it would have neither been a copyright infringer nor run afoul of the DMCA. Some also argue that the DMCA has chilled scientific research. I'm not persuaded by these concerns. To the contrary, it appears that any chilling effects felt by scientists and researchers are due to the rhetoric of DMCA critics rather than the DMCA itself. There has been no DMCA conviction of computer scientists or researchers. There have been no DMCA suits or prosecutions brought against scientists or researchers. There are 2 cease and desist letters out there. The recording industry did send Professor Edward Felton a letter raising the specter of DMCA liability, and Hewlett-Packard sent a similar letter to members of the Snowsoft group, who might loosely be termed researchers, but both RIA and HP quickly backed down and announced they would not bring suit. So on what rational basis do scientists feel research will subject them to DMCA suit? If no one has been sued after 5 years, they should draw the opposite conclusions. Furthermore, the DMCA contains 3 specific exemptions from its prohibitions that are applicable to scientists. 1201F allows circumvention in the course of reverse engineering to create interoperable software. 1201G allows circumvention in the course of encryption testing. and 1201J allows circumvention in the course of testing computer security. Congress put these in the statute specifically to address concerns that the DMCA would have an effect on researchers. But no court has ever had to interpret these provisions, so we don't know how broad or narrow they are, because no suit has ever been brought against a scientist or researcher. If no scientist ever gets sued, these exceptions are superfluous, and really, again, scientists and researchers shouldn't have a concern. Some also argue that the DMCA limits First Amendment rights. Once again, these arguments are unpersuasive. In fact, the only courts to consider this issue, again, the Elcom Court and the Corley Court, found the DMCA does not violate the First Amendment. While the DMCA does limit the dissemination of certain software programs, and while software is certainly protected as First Amendment speech, the courts have found that the DMCA does not violate First Amendment rights. The DMCA limitations on some software programs like DCSS are directed at the functionality of those software programs rather than their expressive elements. Thus, to the extent DMCA may limit dissemination of First Amendment expression, it is content neutral. Further, the courts found that the DMCA serves substantial government interests, namely protecting copyrighted works, encouraging creativity, and stimulating electronic commerce. Again, I would argue the evidence is all around that it's worked to do those things. As a content-neutral regulation that advances this important government interest, the DMCA does not violate the First Amendment. To the contrary, the DMCA stimulates and promotes the exercise of First Amendment rights by giving copyright creators added incentives to create new works. Since the DMCA provides creators with some assurance that their creations will be protected in the digital environment, they have incentives to make new works available in the digital environment. In Eldred versus Reno, a case that I guess you've talked about a little bit earlier today, the U.S. Supreme Court explained why copyright protection promotes rather than limits First Amendment rights. I hear quoted a lot provisions of or parts of that case that very rightly point out how fair use is a critical concession to the First Amendment, but I never hear those same people quote the other parts of the decision that also discuss the First Amendment. The court said copyright, and this quoted a previous case, I think it was the HarperCollins case, copyright provides the engine of free expression, quote unquote, by encouraging creators to create. Second, copyright only covers expression, not ideas, thus does not limit access or use of ideas. To the contrary, since copyright protection encourages creators to express their ideas, copyright encourages the dissemination of publication of such ideas. Further, since the DMCA does not impact fair use, it does not impact the First Amendment rights accommodated by the fair use doctrine. While I believe that the current copyright regime promotes rather than limits creativity and fair use, I also believe the future does present some serious concerns to the continued creation of copyrighted works and the fair use that creation allows. Unlike some, though, I see the greatest future threat as the weakening of copyright protection, or at least a weakening of the ability, the real-world ability, for creators to protect their copyrighted works. The most direct manifestation of this threat is the unbridled copyright piracy that is occurring today. Copyright piracy has grown to unmanageable levels and appears to be skyrocketing out of control. My fear is that skyrocketing piracy will destroy legitimate markets for copyrighted works, depress creation, and thus rob consumers and fair users of the next great software, movie, or music creations. Hard good piracy has long been a problem for copyright owners. Lately, however, it has mushroomed in size and impact and has become increasingly difficult to control. In 2002, the U.S. software, movie, music, and book publishing industries suffered between $20 to $22 billion in piracy losses in foreign countries. There are no numbers for losses suffered by other types of U.S. copyright holders like photographers, graphic designers, and needlework designers. While U.S. copyright owners devote great efforts and resources to stopping hard good piracy, there is little hope they can stop it alone. Organized criminal involvement in copyright piracy has become commonplace, and copyright owners do not have the resources to deal with such gangs alone. Law enforcement agencies cannot fill this gap as they must, understandably, devote more resources to terrorism and security threats. It has also become easier and cheaper to engage in hard goods piracy. In years past, a multi-million-dollar investment was necessary to set up an optical disc replication factory. and the size and permanence of such a factory made it vulnerable. Today, dozens of linked DVD or CD or DVD burners can churn out thousands of pirate discs in a small apartment and can be disassembled, and moved with relative ease. The greatest threat to the creative incentive and to the fair use creation engenders is online piracy. While by now it's trite to say so, it's nonetheless true that a single copyrighted song or needlepoint design can be illegally distributed to thousands with the click of a mouse. Online piracy is not a theoretical concern, it is real. Organized online gangs like the recently busted Drink or Die crew make it their mission to steal pre-release copyrighted works, break their DRM protections, and illegally distribute them through the internet before their commercial release. Though less nefarious, casual online infringers also pose a great threat to copyright owners. Take the example of Lynn Skinner, a LA-based needlework designer. Was a constituent of my boss's in the last Congress, but now after redistricting, she's just outside of his district. For years, revenues in the needlework industry averaged around $500,000 per year for the whole industry. And Lynn was doing a decent business creating and selling needlework designs. Today, widespread copying and distribution of needlework designs by needlework enthusiasts on IRC channels and FTP sites has destroyed Lynn's business. She tries to stop them, she sends them emails, she goes on these IRC channels herself, and they just laugh at her. These are needlework enthusiasts. They don't see anything wrong with it, but they've destroyed her business. And then, of course, there are peer-to-peer systems. While P2P technology is itself remarkable, its misuse for copyright infringement is not only rampant, but is its predominant use. There are 4.5 million users on Kazaa at any one time, trafficking in well over 850 million files at any one time. The vast majority of these files, approximately 89%, are illegal copies of copyrighted works for which the copyright owners receive no compensation. Unauthorized P2P trafficking in copyrighted works is copyright piracy. As the Ninth Circuit held, there is no colorable claim of fair use that excuses these infringements. The attempt to make such an excuse ignores not only the reality of the theft, but is an insult to creators. It is a copyright owner's right, not a pirate's, to choose whether to distribute a copyrighted work through a P2P system. If the copyright owner wants to use P2P to distribute his work, that's great. If not, the owner has the right to refuse. The argument about the propriety of illegal P2P file trafficking should end there, but some try to further excuse this theft. They make patronizing assertions that copyright owners actually benefit from this massive theft, and thus should welcome the usurpation of their property rights. The truth, of course, is that P2P file trafficking causes great harm to copyright owners. On an individual level, each illegal P2P download of a song robs a songwriter of at least 8 cents. General economic indicators also show the extent of harm. Revenues from sales of music CDs plummeted over 20% in 2002 and 2001, and the sales numbers for January 2003 indicate more of the same. These sales declines cannot be explained away as reflections of a general economic downturn from 2000 to present. Economist Harold Vogel has charted a rapid decline in unit sales of CDs since 1999, well before the current economic downturn, and noted that this decline corresponds directly with the introduction of Napster. To summarize, I think that skyrocketing online piracy and increasingly unmanageable hard goods piracy threatens to end the golden age of fair use and creation. If allowed to continue, piracy will rob many copyright creators, from big movie studios to individuals like Lynn Skinner, of the economic incentive to create. Less creation means less fair use, less choices for consumers, and ultimately a less robust public domain. These are outcomes that should concern all consumer, fair use, and public domain advocates, and against which they should unite.
And now for an opposing view, Dean Marks. No. Our final speaker, Dean Marks, is senior counsel and particularly concerned with intellectual property at AOL Time Warner. Dean is that rarest of the human species, an American, who was actually born and raised in California and not merely a current resident. Dean graduated from from Stanford undergraduate school, and then from Yale in 1985, and in the years since has held a very wide and impressive array of positions in copyright policy, copyright lobbying, For the last 13 years, he has been part of the AOL, or let me just say the Time Warner operation, and comes to us now as someone whose views I think will in fact elaborate upon the things that Alec has presented, but from the perspective of the corporation in the field for whom these matters matter in a somewhat different way. Dean? Thanks.
Thank you, Professor. I'm going to stand up since I put this PowerPoint up trying to make it a little colorful since I was the last speaker of this morning. I thought something to keep you folks awake. I first want to begin my remarks by saying that I'm speaking here in my personal capacity, and somewhat like Alec, anything that you like that I say you can attribute to the company, and anything you don't, please don't. But it's no surprise that I agree with a lot of what Alec has said, and in fact he's covered many of the points that I wanted to cover. But what I thought I would talk about today is really more from the perspective of a corporation that's out in the field, a corporation that's very concerned about protecting its copyrights, but a company that's also very, very concerned about fair use. Time Warner comprises all of the magazines of Time, the news reporting of CNN. We're very concerned about fair use. We rely on fair use every day in our news reporting and in creation of certain of our products. And in fact, we've been on all sides of these copyright issues, from protecting our works like with Joe and DC Comics against being ripped off, but we were on the other side of a major fair use case in the Second Circuit called the Ringgold case, where HBO had taken a shot, used a poster in one of its programs and had not gotten proper clearance for it, and argued that it was fair use, and in fact the court found that it was not fair use. So we're really on sort of all sides of this issue. One thing I wanted to mention about this whole First Amendment balance with copyright law, and Alec mentioned it, and Professor Patterson was speaking of it as well, and I think it's something that, particularly as one is beginning the study of copyright, cannot be forgotten, which is that copyright law does not protect ideas. Copyright law only protects original works of authorship that are expressed in tangible mediums. So there is sometimes this thought that copyright law is a vehicle for locking up ideas, for preventing expression, and I personally do not think that's the case, because the copyright law protects the original expression. It does not protect ideas. So I will go to my first slide. My topic really is technical protection measures and the fair use balance. The DMCA, the interesting parts of the DMCA and the ones that are the most controversial were enacted to give legal protection to technical measures. I thought my talk I would focus on technical protection measures and the fair use balance. This first slide is just setting sort of what the context is. There are certainly and obviously tremendous benefits for digital technology for consumers, but for content creators as well. Digital technology enables us to create higher quality works. We can create them more cheaply. We can store them more easily. They're not subject to degradation. It increases the efficiency with which copyrighted works can be distributed to the public, and it can lead to a lot of greater consumer choices. So there are obviously huge benefits to digital technology. The risks are also clear as well, and Alec described some of them. And particularly to copyright owners, it's the risk of damage to legitimate economic interests by massive unauthorized copying and redistribution, particularly over the internet, and particularly through burning of digital copies, where the millionth copy at first, a big change from the world of analog piracy, which required investment in huge, in the case of video piracy, lots and lots of video recorders and having to make duplicate copies, and it was a much more, if you will, clunky form of piracy that was easier to keep under control. So these changes in the world and the introduction of digital technology have really led to the importance of technical protection measures as a vehicle for protecting copyright rights and for combating piracy. And this introduction of technical measures led to a concern that, gee, the technical measures are out there, technical protection measures. What do I mean by that? Encryption, watermarking, technologies like macrovision that help prevent the copying of a digital DVD or an analog VHS to another video copy. There was a concern that these technical protection measures needed to enjoy a certain degree of legal support. Otherwise, it would just be a continual cat and mouse game between the inventors of the technology protection measures and the hackers who would bust them. And if there was not some legal protection for the technology measures, there was a fear that the digital piracy concerns would really overtake the benefits of the digital technology. So, whoops. This concern was not just a domestic concern of the US, but actually an international concern. So international copyright law was updated through the WIPO treaties. There was the WIPO Copyright Treaty and the WIPO Performances and Phonograms Treaty that were negotiated and resolved in a diplomatic conference in Geneva in 1996. And those treaties contain a provision, it's Article 11, I believe, of the Copyright Treaty, saying that member countries of these WIPO treaties have to provide effective legal remedies against the circumvention of effective technical protection measures. We in the US implemented that treaty provision in the Digital Millennium Copyright Act, the DMCA, that Alec spoke of. And so what is the importance of these protections? Again, it's to give the legal protections of the technical protection measures to help protect against the increased threat of piracy, to promote the development of electronic commerce, and to encourage the availability of copyrighted works in digital form on the internet. These are some of the reasons that are specifically cited in the legislative history behind the DMCA. I can't seem to get this to stay straight. So, what about us and the entertainment industry? What is our approach to technical measures? Well, we use technical measures in the entertainment industry to try and promote distribution of our works in new formats. So there's DVD video, as Alec spoke about, and DVD audio, MovieLink, MusicNet, these other online services. And what's the point of these technical measures? Are we implying these technical measures to prevent consumers from using our works? Actually, that's not the case. As the copyright industries, we only survive if consumers consume our works and think that the works are valuable enough to pay to use them, to see them, to read them, to hear them. If the works are either A, cruddy, and nobody wants to go see our movies, like Pluto Nash, one of our recent wonders. You know, thank goodness we have The Lord of the Rings and Harry Potter to counteract Pluto Nash. But, you know, if the work isn't valuable, consumers aren't going to go and consume it, and, you know, we're going to lose our investment. If the work and copies of the work that are distributed to consumers aren't seen as a reasonable economic deal for the consumer, for example, like the DVD, then the consumer isn't going to buy it, and the consumer is going to go somewhere else for their entertainment. So what we try and do with technical measures is to apply them in a way so that we can make a differentiated series of offers to a consumer. What do I mean by that? What I mean by that is if we put out a movie, we could put it out on a DVD and you could buy it for $15. We could make the movie available on video on demand and you could see it for $3. Problem for us if everybody who takes a video on demand for $3 and makes a permanent, if Professor Patterson would call it, a personal use copy of it. What does that do for the DVD market? It would really erode that market. So what would be the consequence? The consequence would be if we thought everybody who was receiving a video on demand was going to make a permanent copy, we would charge $15 for the video on demand instead of $3. So the technical protection measures, which would, for example, prohibit someone from copying a movie that they had received on video on demand, is what allows us to offer that option at a lower price to the consumer. And so that is the purpose behind it for us, so that we can make differentiations in our offers to consumer so that somebody who wants to see the movie once can pay a rental price and not have to pay the price of someone who wants to have that movie as a permanent copy for their own personal use. So the prerequisite here is that protection measures are implied to maintain meaningful distinctions among these choices, and that's why we also need the legal measures provided by the DMCA to give legal backup to the enforcement of those protection measures. Now, it sounds all fine and good, okay? We're applying all these protection measures. It's actually an incredibly difficult process, and I've been there from the beginning with DVD audio, and the other efforts that we have made. These protection technologies need to function in a mass market of playback devices. You cannot apply Fort Knox sort of encryption and technology and say to Panasonic and Sony, okay, here, put this really sophisticated protection technology into your DVD players, even though we know you're going to be selling those for under $100. It's got to be protection technology that is very cost efficient to apply. And you know, I'm making the point there that we then need to use it to try and limit the piracy, facilitate our distribution, and make meaningful distinctions. And what about circumvention? You know, and Alec touched on this a little bit. Somebody has a DVD, has a series of DVDs. You're someone who wants to make an educational campaign against smoking and how movies promote smoking among kids or something like that, for example. You want to take clips of different movies that show actors smoking and portraying it as something that's cool and socially desirable. Clearly, that would be a fair use. Clearly, in my mind, you know, you're doing something for an educational purpose. You're taking these various clips, and you want to take the digital clips from the DVD. The DVD's protected by CSS. You can't do it. You think, I should be able to apply a circumvention device like the DCSS program to hack through the protection in order to make this fair use. The answer is, under the law, you can't. I should say, under the law, the DCSS software is still illegal as a circumvention device, even if you're putting it to the fair use. Why is that? If you said circumvention devices can be legal when they're used for fair use and illegal when they're used for pirated use, there's no way to distinguish when it's going to be used for one or the other. The hack program, the DCSS program, all it does is destroy the encryption for the DVD. It doesn't know to what use it's being put. So that's why Congress decided, no, there can't be an exception, a fair use exception to the anti-circumvention provisions, particularly with respect to devices and programs and circumvention products, because otherwise the exception would swallow the rule. As Alec, by the way, correctly pointed out, in copy controls, there's no prohibition in the DMCA on circumvention conduct itself. The critics of the DMCA have said, well, great, so the DMCA allows us to circumvent, but doesn't give us, but makes the tools to circumvent illegal. I think there's a fair criticism there. The rationale, though, is if you made the tools legal and the tools can't distinguish between a legitimate fair use and a pirated use, the exception would swallow the rule. That's the balance Congress struck. So I want to get into what is fair use, and Professor Patterson and Joe Beck, you know, touched on this, and I think it's very important that we not lose sight of the legal basis of fair use. What is convenient to do, what's easy to do, what I can do in the privacy of my own home on my PC, and even if I'm doing it for no commercial gain, that doesn't necessarily make it fair use, even if in your own mind you might feel, well, it seems fair to me. That's not that's really not what fair use is about. Fair use is a legal defense based, at least today. Professor Patterson may not wish it to be so today, but at least under today's law, it's a legal defense based on a carefully balanced inquiry involving 4 factors, which are set out in Section 107. And I've just set out these factors here. I think fair use is an incredibly fascinating area of the law because it is so unpredictable, which is not always a good thing either for copyright holders or for fair users. And as Joe Beck alluded to, and as I think the judge is concerned about, one of the really interesting and even troubling issues in fair use is if you went on a fair use defense, boom, it's fair use, you've got a free ride. Alice Randall owes no royalties at all to the Mitchell estate for Gone with the Wind. If you lose on a fair use case, like in the Dr. Seuss case, boom, injunction, and that work, you know, leaves is unavailable in the marketplace. It's sort of an all or nothing determination, and a lot of people are troubled by that. I mean, Judge Kaczynski is also troubled by that, and but when you think about it, so what's the alternative? Is it compulsory licensing? Is it saying, okay, you guys have to get to the table and figure out some way of paying fees for this use? It's very hard and troubling when you think about what some of the alternatives are there. So getting to the traditional fair use, which has been mentioned by Judge Patterson, versus consumptive fair use. I call it consumptive fair use. I think that's probably what Professor Patterson would refer to as personal use, but maybe not, and we can talk about it during the discussion on the panel. But the traditional fair use involves comment, criticism, educational use, which don't necessarily have to be transformative. If you're doing excerpts of things and making copies of them for educational use, it's not that you're necessarily doing anything to change or bringing any independent creativity. Same thing for news reporting, but it's a public interest use of the work. That's the traditional fair use, and then of course all of the transformative uses, like in the When Done Gone and the song, the woman's song that we heard at the beginning. Those are transformative uses such as parody. Those are the traditional fair uses. Consumptive fair use, as I call it, is mechanical copying of the entire work or copy of the work for purposes of convenience or consumption by the consumer. And some consumptive uses are considered fair use, and the most notable case, and the case that if you don't know about it yet, if you study copyright law, you will surely know about it, is the Betamax case or the Universal versus Sony case. That was the case about the VCR and time shifting of free over-the-air television on the VCR. And it was the first fair use case, and it's a Supreme Court case, to hold that mechanical copying of the entire work was a fair use. But so it did establish the principle that yes, mechanical copying of an entire use for personal consumption by a consumer can be a fair use. But the rationale was pretty limited in that case. The court deemed that most of what was happening on the VCR was time shifting of the broadcasts for viewing at a later date and then the broadcasts being erased. So the court did not address permanent copies for retention or librarying purposes. It was only addressing time shifting of free over-the-air broadcasts. So the court said these broadcasts are already made free to the public, so the fact that a member of the public copies it to view it later does no economic harm because the consumer's not paying for the broadcast in the first place. The court specifically was not addressing pay television or pay-per-view models. Again, the permanent retention of the copies wasn't at issue. The use was non-commercial and personal use, and then the court found that there was no harm to the market or potential market for the copyrighted works. So the question is, now that we're applying some technical measures, for example, to the DVDs that make it difficult for someone to make a copy of it, are we impinging on fair use? Has the balance with a fair use gotten out of whack? I would argue no, and I would argue very importantly because the technical measure protects only the copy of the work, not the work itself. And I think that's a very important distinction to make. When you think about traditional fair uses of comment, of parody, of criticism, that has nothing to do with the fact that you can't slavishly and mechanically copy the copy of the work. If I'm going to write a book like The When Done Gone, it doesn't matter that I can't reproduce the electronic copy of it. The fair use that I'm making is involving, creative component that I'm bringing to my use of the work rather than just a slavish reproduction of a copy of the work. So technical measures do not impinge or impair on any of those sorts of fair uses. And as Alec alluded to, the courts that have considered this, particularly the Second Circuit in the Universal case, have concluded that fair use has never been held to be a guarantee of access to copyrighted material in order to copy it by the fair user's preferred technique or in the format of the original. go back to my example of the professor or the medical health field advocate who wants to put together a series of clips about smoking in the movies. You can do that by either taking clips from the analog VHS that are out in the field, or if you have the DVDs, you could actually camcord it off the screen. You may say, come on, that's ridiculous, it's going to be a crumbing copy. Well, actually camcording is one of the sources of the greatest piracy of our movies when they're in theatrical release, and the camcorder versions are often pretty darn good. So that is really the balance that's struck there, saying, no, fair use doesn't mean you get to get the copy of the work in its most pristine format or in the format you would prefer. A really example I think that drives that to home is that before the video business, and before there was a video business, no one would argue that a movie studio had to make its 35 millimeter prints available and open its vaults for people to come in and take clips of it. I don't think anybody would have made that argument that fair use demands that. So again, what about these circumvention devices? I've already touched on this. The problem with circumvention devices and programs is they cannot distinguish for what use they are being made. And so therefore, while the prohibition to use circumvention devices to circumvent technical measures may make certain fair uses more cumbersome, the balance needs to be struck between the risk of convenience of some of those fair uses and the risks of piracy. And if you say that there has to be convenience of fair use and fair use at any price, it really does mean that fewer works are going to be made available in fewer formats. Alec touched on that with the DVD. I want to really drive that point home. I was there with the creation of DVD. Time Warner and Warner Brothers was one of the studios that was at the forefront in pushing for the creation of the DVD format. And it is absolutely certain that no movie studio would have released its movies on DVD but for the fact that we could apply some sort of encryption and protection to it. And even with that, there were several studios who were very, very reluctant to release on DVD. They said they would say to us, the video business is a healthy business. The rental of video cassettes is a healthy business. Why would we want to put out a new digital format that's going to erode the golden egg that we already have in the video business? You cannot imagine the discussions that went on. If we had been required to put out a digital format in the clear that was subject to the sort of easy reproduction and redistribution that the compact disc is, because the CDs are in the clear, they never would have emerged on the market. I can assure you of that. And they barely made it out there to begin with anyways. As it turns out, it's been something that consumers are widely popular with consumers, and it's been a big boon to the movie industry. And we really do not hear consumer complaints of people who say, darn it, I want to be able to make a copy of my DVD and I can't do it. So that was the balance the Congress struck in the DMCA to say that it's unlawful to traffic in tools that allow circumvention, even if those circumvention tools can be put to fair use. And that balance has been upheld by the courts in the Ramirez case, which was the district court case before it reached the Second Circuit in Corley, and in the Elmcon case in the Northern District of California. So there's the legal basis. What are we doing practically in the field as a company, as AOL Time Warner, in our technical measures? Well, in fact, we are not adopting technical measures that prevent all sorts of personal use. We are on certain formats. DVD, you're paying for the copy to retain the copy, so therefore that DVD is protected to prevent further copying of it. Same thing would be for a video on demand, where we're working to be sure that if you buy the video on demand and you're buying it for the rental price to see it once, that you not be able to make a copy of it. But in our work to protect, for example, digital over-the-air broadcasts, and some of you may have heard of the efforts with the broadcast flag that is now before the FCC, no limitations on numerical copying there. The technology that's been developed by Intel and Sony and Matsushita and Toshiba and Hitachi for protecting digital broadcasts in the home so they can be, or digital transmissions, so they can be moved around the home to various devices. Again, allowing copying of basic cable programming, allowing copying, first-generation copying of pay television broadcasting. Those technologies, and there are rules and the licenses for those technologies that actually restrict content owners from being able to apply, for example, the digital transmission technology to prevent any copying. The copyright owners are aware, and we've negotiated those licenses with those technology providers, that we want to facilitate a certain amount of personal use copying, and particularly, the ability of a consumer that if they see a broadcast and they want to copy it and then they want to move it to their personal device, that they can do so, or a portable device. The key for us is really preventing the unauthorized consumer redistribution that erodes legitimate commercial distribution. So how do we do this? We work in these incredibly lengthy, complicated, and sometimes frustrating cross-industry negotiations to develop and implement these voluntary technologies and protection measures, such as the CSS for DVD and this DTCP is digital transmission content protection for digital transmissions. And we try and do most of this through a voluntary cross-industry process of developing these technologies. Where there are some areas where there are gaps of protection and need to level the playing field, we've been seeking very targeted, limited legislation, such as on the broadcast flag or the macro vision provision in the DMCA. It's a very difficult task and a difficult challenge because we deal with an environment that has a mixture of analog devices and digital devices and the easy conversion from analog to digital. We have a mixture out there now of consumer electronics devices like DVD players, video cassette players, and personal computers. Very much simpler to build in content protection technologies that function the way they're supposed to, and a freestanding, single-purpose consumer electronic device like a DVD player or a video cassette recorder. Much, much more difficult to do it in the PC environment because the personal computer by its nature is open to modifications and programmable. It's much harder to do. It can be done successfully. Every DVD-ROM drive that's out there in personal computers today is licensed for the CSS encryption, and under that license, that DVD-ROM drive has to protect the content from a CSS encrypted DVD from being subject to being digitally output without protection, or even output through an analog output without macrovision. But it's a tough thing to implement. Then, of course, there's legacy equipment. You look at the music industry and you say, why doesn't the music industry just start encrypting their CDs? Well, if the music industry started to encrypt its CDs, they would not be playable on any of the installed base of CD players in the billions of homes and cars and other places where CD players are. So you always have to be dealing with that problem of legacy equipment. It really only becomes practical to introduce technical protection measures on new formats like DVD. And then, of course, content arrives to consumers through all sorts of different sources. You have physical media, you have transmissions, you have broadcasts, and it's difficult to necessarily implement the technical protection measures on all of those formats. And finally, in the end, this is from one of our engineers, humans are standalone wireless analog receivers. For us to actually perceive the content, to view the content, to hear the content, at the end, it has to be transformed into light waves and sound waves that we can see and that we can hear. And as one engineer from one company said, if I can see it, I can copy it. So technical protection measures, can only go so far in terms of their protection. I was going to put up a slide on the analog hole, but I think I will not torture you with that and leave my remarks at that. And thank you for giving me the opportunity to come and speak to you.
And indeed, thanks to all 5 members of the panel. These are the initial presentations, and by definition, it is now 10:45. We will therefore repair to the loggia immediately outside this room for about 15 minutes for some refreshments, and then we'll regroup. The question and answer session will be somewhat shorter than scheduled, but there will be one, and if you return promptly in 15 minutes, we'll commence it promptly. Thank you.